supposed to tell you what it's 9 but it was that was always communicated because of that. It's supposed to be So you told me that it's coming.
Yes, it's coming. He'll be around.
How are you?
Babo. Hata umekuja.
It is such secret.
Just a second.
Let him translate. Abubakar. Let him.
No, I'm just talking about something.
I'm not taking it.
We are like scissors.
Society of Kenya versus Inspector General of Police.
I'm here together with Kabata Mwaura, the Vice President of the Law Society of Kenya, Hosea Manwa, Kabata Mwaura, Hosea Manwa, who is a council member, Ramadan Abubakar, the Vice President of the East African Law Society. The second one is Hosea Manwa, council member of the Law Society. The fourth is Ramadan Abubakar, the Vice President of the East African Law Society. Next is Rebecca Onwenga, followed by Levi Munyeri, then Ms. Leila Hassan, then Nurdin Kagai, then Crispin Migele, Gad Aguko, Nyabira Hargreaves. Perhaps you just say Nyabira H. And then Mwalimu Evans Okada. For the respondents, you have my senior and learned friend, Mr. Miller, appearing together with my friend, Mr. Ogola, for the first respondent. For Mr. My Lord, my sincere apologies are being reminded that Mr. Simiu is for Mr. Lazarus Opicho. Is for Lazarus Opicho. So, my Lord, I was indicating we are here for two issues. One is for Mr. Lazarus Opicho to respond to the summon given to him by the court on the 9th of September. I've seen him in court. Then secondly, after we are through with Mr. Opicho, my Lord, we are here to receive the ruling in respect to the sentencing of the Acting Inspector General of the National Police Service, Mr. Gilbert Masengeli. I believe that is what brought us today in court.
My Lord, my client has complied with your summons pursuant to your ruling of 9th of September 2020. My Lord, I'm instructed to inform the court that my client indeed communicated with the officers as alluded in the ruling. My Lord, that communication is purely operational to ensure, my Lord, that those officers serve you in the best way possible. My Lord, there was no intention whatsoever to intimidate or in any way demean the authority of this court. My Lord, if the call was misunderstood, my client apologizes for the misunderstanding, but the intention still remains clean-cut. My Lord, for that reason, we pray that my client be discharged.
Or is it that you are called and there are no complaints that you
Look, my Lord, coming from the background of the security challenges we've had in Makadara, which we all are aware of, and generally the noise that has been around, my client routinely calls officers for operational issues.
One thing is he trying to establish, and I trying to find out exactly what was the nature of the communication.
Yes.
And he told me that all he wanted was to know my whereabouts. Mr. Picho, he has my number, he knows. Why can't he just call me directly?
Yeah, my Lord,
Establish my whereabouts.
that's why my Lord, I said it was...
Mr. Picho, why didn't you call me directly? You have my number.
Thank you so much, my Lord. First and foremost, I want to really...
So was there anything that you were trying to find out about him?
Unfortunately, my Lord, I want to assure this court, I've worked with you, I'm the founder of GPU, I've worked with all of you very well, and indeed you can confirm that I've never had any issue with any person.
You confirm that, but
Very unfortunate, Your Lordship, I'm sorry, that will not be repeated again.
I will accept your apology because
Thank you so much.
I think that is not right.
Thank you, sir.
Particularly when you call officers who are in charge of security and you try to find out from them keep that to yourself. You don't tell me anything.
Thank you, sir.
I really want to find out from them much later that you will call him to establish it. And it's not just one, you call both of them at different times.
Thank you, sir.
So that worried me.
I'm sorry, sir.
All right, I will accept your apology, and
Yes, sir.
I hope next time that you'll be able to communicate better. If you have any issues, I know you are in charge of security, but I think this is what the problem is. But I don't think it is right. If you have to call them on their own issues as police officer, that is okay. But when you
Thank you, sir.
take it to the point of you want to know exactly where I am, and not from one officer, but both of them,
True, sir.
and they were in separate locations that time. They were not there. They were not at the same place.
There's 200 million there, sir. You're
If
right.
you not get the information you wanted, then you call the other. So I was concerned that why would you be so much concerned about the whereabouts from the two officers?
I'm
So
sorry,
you
sir.
are not calling me directly.
I'm sorry, sir.
What is it that you are looking for? Which you could not ask me.
I'll
I
endeavor
would
to
have
serve.
told you that I'm in Nairobi, I'm in my rural home. So that whatever happens, happens. But I hope there is nothing that will happen. Anyway, thank you.
Thank you, sir. And I'll endeavor to serve you well.
Yes, yes, yes.
Thank you.
Issue. Now, where I'm supposed to deliver my ruling, my sentence, and the first one. Proceed.
Yes, my lord. We filed an application dated the 12th of September on behalf of the first respondent applicant. We took the liberty of serving the first petition. My lord, without going into the merits of the application, the said application seeks, on the basis of the fact that between conviction and sentencing, a court may move the court to discharge the conviction and that is what that application seeks to do. My lord, our humble view and plea is that this court gives directions on our application that was filed under certificate and thereafter, once directions are given, keeping in mind, my lord, that I believe there's an application of the petitioners that has not yet been heard. The most prudent thing to do
My lord, simply because of the nature of the application, have the decision finding the first respondent in contempt of court to be reconsidered, my lord. And I believe that owing to that nature of that application, it has precedence, my lord, over the sentencing that it seeks to stay. So in terms of the hearing calendar, I propose that we deal with that application now that it is before court, before we take directions the issue of sentencing law, because it may affect the issue of sentencing law.
Start with the application by the first respondent. However, on our part, we shall not be objecting to the second application. That would be all.
Make directions as and when that application will reach you. It doesn't reach you.
Mr. Miller, don't you think your application is too late? It's coming too late in the list.
My Lord, with all humility, we do not feel that the same is late on account of the fact that there are various authorities that state that at any point in time between conviction and sentencing, contempt can make an application. So we're within the legal rights and legal foundations for making such an application. Secondly, my Lord, due to the nature of work that the first respondent is involved in, getting to be able to get instructions adequately and on time has been a challenge, but the same should not be used against him, because what has kept him very busy are issues of national security.
You may be forced to write a ruling, yet you are not supposed to write a ruling on what my learned senior is dealing with, and that's why
Now that he is before the court, let him get
out.
Matters of national security in particular, without delving into the application. The affidavit in support of that application outlines the challenges he's been facing. So, with all humility, my Lord, with your kind permission, if I can just address the court. Most of it.
This is the rule of sentence. I'll start with a brief background of the present content of court proceedings. On the 23rd of August 2024, the first petitioner approached this court via a notice of motion application under Secretary of Agency, alleging the abduction or arrest of the second to the fourth petitioners on the 19th of August 2024 by persons who had introduced themselves as police officers. They were then kept in undisclosed locations after the incident. The court issued ex parte orders in the first instance as follows. 1. That pending the hearing and termination of this application inter partes and only is hereby issued, directing the respondents to immediately disclose the whereabouts of the second to the fourth petitioners to the first petitioner. That pending the application, the hearing and the termination of this application inter partes and only is hereby issued, directing the second respondents to immediately release or produce the second to fourth petitioners before any court of competent jurisdiction to make such requests as may be appropriate to uphold the rights and fundamental freedoms of the second to the fourth petitioners. 4. That the matter was then fixed for mention on Monday the 26th of August 2024 at 10 a.m. to confirm compliance. During the virtual session held on 26th of August 2024, only the advocate for the petitioners, Ms. Omanga, appeared. She informed the court that the orders made on 23rd of August 2024 were duly served, as was evidenced by the affidavit of service. However, there was neither appearance by any of the respondents or responses to the habeas corpus application. There had been no compliance with the orders either. That necessitated the court to write responders in which it directed that pending the institution of the charges, if any, the court now directs the unconditional release of the second to fourth petitioners by the first respondent. Number 2, that physical service of the order be effected by close of business that day. And number 3, that summons to issue to the first respondent to appear in court on the next mention to explain why the habeas corpus issued by the court were not complied with. The matter was fixed for the 9th of September 2024. On the morning of the 9th of September 2024, the Attorney General, the DPP, and the Director of Public and the Director of National Intelligence Service, the Inspector General of Police, and the Director of Criminal Investigations appeared in group counsel. None of them had filed a response to the application, and the orders of the 23rd of August are not being complied with. The Inspector General of Police, who the court had summoned, did not turn up either. The court postponed the matter to 3 p.m. for physical attendance of the Inspector General to explain why the habeas corpus orders were there untrue. The afternoon came and passed. The Inspector General of Police did not attend. The court was informed that he was out of office on official business, with the nature of business being revealed to be a workshop he was attending in Mombasa on budgeting that particular morning. In the afternoon, the court was told that he was engaged in security operational duties in Costa Rica. The matter was rescheduled to 5th of September 2024 at 10 a.m. as the court was keen to establish why the habeas corpus orders could not be executed in respect to the production before the court or the release of the second and fourth petitioners. Ms. Mwangi, who appeared for the Inspector General, explained as follows when pressed to explain the apparent persistent disregard of the court summons by the Inspector General of Police. The Inspector General of Police has not said he is not coming. He is requesting for another date because it is our position that the second to fourth petitioners are not with the police. The Inspector General of Police is requesting another date to appear because we had thought his officers would explain. The Inspector General is requesting another date to appear in court, and after holding some brief constitutions, Ms. Mwangi saying the Inspector General of Police will come on Monday, 9th of September 2024. The officers of the Inspector General of Police are here and have confirmed his availability on Monday, considering his work and duties, end of quote. The court, after this brief session, fixed the matter to 3 p.m. on the same day. Despite the court convening, the Inspector General did not show up. The court finally and reluctantly agreed to give the final opportunity to the Inspector General of Police to attend court, coinciding with the date that the counsel for the Inspector General would be available. This was after she had made some brief consultations. The date was Monday, the 9th of September 2024. On that day, the court distressingly wrote, and I quote, "The stream of reasons and excuses by the Inspector General of Police are definitely bound to run out. To proceed at this juncture and history make a finding of contempt of court may be seen as premature in a grave matter of contempt of court, which is a form of criminal sanction, being an offense against the administration of justice. Our constitution requires a high threshold of criminal matters. Reluctantly, the reasons for non-attendance today must be considered. It is thus necessary that I postpone these proceedings to Monday, the 9th of September 2024. The Inspector General, having earlier indicated his availability on this particular day, should have no further excuse but to comply and attend the court physically at 10 a.m. so that the court can put this matter to an end. Due to the persistent non-compliance with both the court summons as well as failure to comply with the orders of 23rd of August 2024, the court opined that it was a case of contemptuous conduct that the Inspector General needed to punch even as he set the date for the 9th of September 2024. That date came and passed through. The Inspector General did not turn up, but he made a last-minute attempt and sent his Deputy Inspector General in charge of Kenya Police to appear on his behalf. The court rejected the arrangement, noting that the open defiance of the court summons had metamorphosed to contemptuous conduct and was now a personal matter that had to be directly and specifically addressed by the person summoned. Following the failure to attend court or comply with the order of 23rd of August 2023, the court entered a finding of guilty for contempt of court against the Acting Inspector General of Police on the 9th of September 2024 and deferred the sentence to Friday, the 13th of September 2024. The sentence. As part of considering this matter from a constitutional perspective, the preamble to the Constitution reflects the commitment of the people of Kenya to attain a number of aspirations. One of them is statement number 6 of the preamble, which states as follows: recognizing the aspirations of all Kenyans for a government based on essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. The Constitution under Article 2, Sub-Article 1, proclaims itself as the supreme law of the land that binds all persons and all state organs. Article 3 obligates every person to respect, uphold, and defend the Constitution. It matters not whether they are mighty or low. The Constitution further proceeds to specify the national values and principles of national governance that bind all state organs and all persons whenever they make and implement public policy decisions, enact laws, and interpret. Among those values and principles are that contained in Article 10(2)(b), which as human rights, the rule of law, among others, whereas Article 10(2)(c) are the principle of accountability. In matters of national security, Article 238 provides that the principles we shall apply and include the following: that national security is subject to the authority of the Constitution, and the national security shall be pursued in compliance with the law and with utmost respect for the rule of law, democracy, human rights, and fundamental freedoms. The rule of law principle is thus a common thread that the Constitution every demands in almost every function to ensure that every person is held accountable to the law. It ensures that equality of all before the law and it prevents arbitrariness. The task of the court is to ensure there is a fair balance by applying the law when disputes arise either between the state and its citizens, or between citizens themselves, or between state organs or agencies. Neither a state organ or its officers or individual is above the reach of the law, as the Constitution in Article 2, Sub-Article 1 declares. The power of the court to adjudicate disputes according to the law is a delegation by the people pursuant to Article 159, which states that judicial authority is derived from the people and vested in and shall be exercised by courts and tribunals established by under the Constitution. The power is exercised subject only to the Constitution and the law, and is not subject to the control or direction of any person of authority by Article 16. The following extract from the South African Constitutional Court in the case of Secretary of Judicial Commission of Inquiry into allegations of state capture, corruption, and fraud in the public sector, including organs of state by Zuma and others, sums up the position of court orders in a constitutional democracy. The court held, orders and decisions issued by a court bind all persons to whom and the organs of state to which they apply, and no person or organ of the state may interfere in any manner with the function of the courts. It follows from this that disobedience towards court orders or decisions risks rendering our courts impotent and judicial authority a mere mockery. The effectiveness of court orders or decisions is substantially determined by assurance that they will be enforced by all and sundry, including organs of state. In doing so, courts are not only giving effect to the rights of the successful litigant, but also, and more importantly, by acting as guardians of the Constitution, asserting their authority in public interest. End of quote. In the civil application, Dr. Fred Matiang'i, the Cabinet Secretary, Minister of Interior and Coordination of National Government versus Miguna and 4 others, the Court of Appeal, affirming the power to punish for contempt, held as follows. When courts issue orders, they do so not as suggestions or pleas to the persons at whom they are directed. Court orders issued ex cathedra are compulsive, peremptory, and expressly binding. It is not for any party, be he high or low, weak or mighty, and white, regardless of his status or studying the society, to decide whether or not to obey, to choose which to obey and which to ignore, or to negotiate the manner of his compliance. This court, as must all courts, will deal firmly and decisively with any party who deigns to disobey court orders, and will do so only to preserve its own authority and the dignity, but more to ensure and demonstrate that the constitutional edicts of equality under the law and the upholding of the rule of law are not mere platitudes but present realities. End of quote. The court entered a finding of guilty. This court entered a finding of guilty on the 9th of September 2024 after all efforts afforded to the contender to punish the contempt were ignored. This was to ensure its authority and dignity, which it is exercised on behalf of the public, does not get annihilated, leading to a situation of impunity and anarchy. The Supreme Court, in Iviliga and 5 others versus Kiriko Tea Factory Company Limited, acknowledged that courts have inherent power to punish for contempt, to vindicate their authority, besides pinpointing the source of authority of Kenyan courts to punish for contempt after declaration of unconstitutionality of the Contempt of Act 2016. The court stated, and I quote, courts possess the inherent power to enforce compliance with their lawful orders through sanctions imposed through contempt of court. We note that the Contempt of Court Act, having been declared unconstitutional in Kenya, Human Rights Commission versus Attorney General and another, 2018 EKR, on November 9, 2018, the instructive provision remains Section 5, Subsection 1 of the Judicature Act, which grants the High Court and the Court of Appeal the power to punish for contempt. It provides the High Court and the Court of Appeal shall have the same power to punish for contempt of court as for the time being possessed by the High Court of Justice in England, and that power shall extend to upholding the authority and the dignity of subordinate courts. End of quote. Today, this court is required to pass sentence for contempt of court. The principles to be considered in determining an effective sentence in a contempt of court matter were considered by the South African Constitutional Court in Jacob Zuma case, where the court discussed the coercive versus punitive order and explained the difference between the two approaches as follows. There is a distinction between coercive and punitive orders, which differences are marked and important. A coercive order gives the respondent the opportunity to avoid imprisonment by complying with the original order and desisting from the offensive conduct. Such an order is meant primarily to ensure the effectiveness of the original order by bringing about compliance. A final characteristic is that it only incidentally vindicates the authority of the court that has been disobeyed. Conversely, the following are the characteristics of a punitive order. A sentence of imprisonment cannot be avoided by any action on the part of the respondent to comply with the original order. The sentence is unsuspended. It is related both to the seriousness of the default and the contumacy of the respondent, and the order is influenced by the need to assert the authority and the dignity of the court to set an example to others. End of quote. The court then went ahead and found that the conduct of the contemptor, Mr. Zuma, had made it undesirable to benefit from coercive order, reasoning as follows. A coercive order would be both futile and inappropriate in these circumstances. Coercive cometo, through a suspended sentence, uses threat of imprisonment to compel compliance. Yet, it is incontrovertible that Mr. Zuma has no intention of attending the commission, having repeatedly reiterated that he would rather be committed to imprisonment than cooperate with the commission or comply with the order of this court. Accordingly, a suspended sentence, being a coercive order, would yield nothing. End of quote. Opportunity to punch the content to the extent that attending a workshop in Mombasa was more important than obeying a court summons intended to seek an explanation on the whereabouts of the second land petitioners, last seen on the 19th of August 2024, the date of alleged abduction. Nevertheless, I took note that on the last date, the contemptor attempted to bring in his deputy to explain the position with regard to the summons. The deliberate defiance of court orders brings impunity, particularly when it is done by those entrusted with public power, as it is inconsistent with the purposes and the objects of the Constitution. In passing this sentence, I am conscious that it is directed to the highest ranked police officer in this country. He is still in office. That might pose a challenge in the enforcement of the order, since in police service, seniority is highly regarded. That, however, cannot deter me from pursuing and standing firm in the defense of the aspirations of Kenyan people who desired at the time of enacting this constitution to have a country that is governed by adherence to the rule of law. Part of the oath of office that I took as a judge states as follows: I will at all times, and to the best of my knowledge and ability, protect, administer, and defend this constitution with a view to upholding the dignity and the respect for the judiciary and the judicial system of Kenya. End of quote. The constitution of this country is supreme, and Article 2.1 reiterates that by stating that it binds all persons and all state organs. No man or state organ or authority is above the Constitution. The Constitution command through this court is that I uphold the rule of law by protecting the integrity of the judicial system. The significance of this sentence today is to vindicate the cherished principle of the rule of law in our constitutional democracy by restoring the dignity and the authority of this court in public interest. Borrowing from the South African Constitutional Division, the contemptor shall serve sentence as follows. The contemptor, Mr. Gilbert Masengeli, is sentenced to 6 months imprisonment. Mr. Masengeli is ordered to submit himself to the Commissioner General of Kenya Prisons to ensure that he is to be committed to a prison facility to commence serving sentence of the imprisonment imposed. In the event that he does not submit himself to the Commissioner General of Prison Service as ordered, the Cabinet Secretary for the National Interior must take all steps that are necessary and permissible in law to ensure Mr. Gilbert Masengeli is committed to prison to commence serving the sentence imposed on him. The court, nevertheless, finds it desirable to impose this sentence as a coercive order as opposed to a punitive order. In that regard, Mr. Masengeli may avoid serving this sentence, and therefore, in that regard, the court shall suspend this sentence for 7 days only. The acting Inspector General of Police can redeem himself and comply by availing himself before this court in person to answer to the issues he has been avoiding in default. The sentence shall automatically become effective.
Thank you. As you're aware, the last 3 weeks we've been before these corridors seeking justice for 3 individuals who are Kenyan citizens who were abducted by police officers. Today marks the last day for the sentencing of the Inspector General of Police for 6 months for failing for 7 occasions to comply with court orders. We are happy that the court has sentenced him because that is what the law provides. The court has also instructed the Commissioner of Prisons to present himself to the Commissioner of Prisoners for the purpose of serving a sentence after 7 days. He has a chance within the 7 days to proceed and redeem himself by doing the necessary and coming back to court and complying with those court orders. After the lapse of those 7 days, he will start serving his sentence. The CS Interior has also been directed to ensure that that order is complied with if he doesn't present himself at the time. It is a good day for the rule of law. We applaud the court for holding him in contempt. He was convicted last week. He has been sentenced today. It is a win for the rule of law, and as the Law Society of Kenya, we are proud that this case will set a precedent for all public officers who hold those offices on behalf of the Kenyan people, that they have a duty to comply with court orders. I invite the Vice President of the Law Society.
Today marks a very special day in what we call rule of law and good governance. It is against a very bizarre background of 3 missing Kenyans who were abducted and unlawfully detained by the police officer stationed at Kitengela police station and later on through various clandestine hideouts. We are not very sure at this particular moment about the safety, about the well-being of the 3 Kenyans, both Njagi, Jamil and Aslam Longton. But today the court has given a new breath of life into our suit. We still are pursuing to get to the bottom of where the 3 Kenyans are, and we are still hopeful that we will find them alive. But of course we also have to be prepared with a mindset for an alternative. Today the court has directed a very strong indication that it will not be business as usual. If Mr. Masengeli does not deliver himself to court within those 7 days, then the alternative is to deliver himself before the Commissioner of Prisons. And the prison that is nearest from here is industrial area prison. I do not think it will take him a long time to get there. But it also is an encouragement to those who pursue justice within the courts, and it emphasizes and strengthens the public trust within our courts. You will remember that we have been to court about 7 times, and in these 7 times the Inspector General has adamantly refused to come to court to explain the whereabouts of these Kenyans. The Inspector General, in fact the Acting Inspector General, may have a very skewed memory, because it is only 2 months ago that his predecessor left office amidst public outroar. And it is at this moment that you have to reflect that it is not a national police force, it is a service. And the service is to the people of Kenya. So that if you fail and you abdicate into that constitutional obligation, and I speak with a lot of authority right now that we will not stop here. This journey has just begun. Mr. Masengeli will be a lesson to public officers who continue to defile and abuse the offices that have been given to them by the Kenyan people. And the Kenyan people are saying they need a new system of governance, they need accountability, and they need openness in how we are dealing with those who have been entrusted with these responsibilities. The Law Society of Kenya is actively going to be engaged to ensure that we have a space where a democracy, where difference in thought, where differences in what we believe in are allowed to take center stage without having the necessary executive fiat of instilling fear, maiming, killing, or thereabouts. So we say to you, also the members of the media, please, you have a responsibility to report accurately, to report what is happening. The sensational reporting may not sometimes be what we are looking into, and we understand the lines that you operate with, and we thank you for your continued boldness in covering and reporting what the Law Society is doing and what even the courts are doing. So the other part of our strategy is for now an internal plan. We may not wish to divulge it right now, but we assure the Kenyan people that all those who are vested with public authority must, I'm tempted to say shall, but must obey the Constitution of Kenya and the laws that have put them there. So I end at that. We will be back on Thursday before Justice Chachabwita, and from there we can take further directions. But as of now, we are extremely strengthened. Our resolve is not shaken. We are going to move forward, and we are going to make Kenya work for everyone, not just those in authority, but all Kenyans. Thank you so much. Yes. The judge has foreseen the possibility of that not happening, and when the judge was extremely graceful to the application, because what we were seeking was an immediate arrest and imprisonment for defiling the record of the court in contempt. In the alternative, if he does not present himself to court in the 7 days, two things will happen. He has been requested by the court, not even requested, directed by the court, that he should present himself to the Commissioner of Prison Services. And I believe, in fact, I was wrong. The Commissioner is just right here. The prison officers are just right at the corner. But in the alternative that he also does not present himself, then the Cabinet Secretary in charge of interior, who is also a member of the Law Society, I have to insist, is directed to make steps to ensure that Mr. Masengeli is arrested and presented to a detention facility so that he can enjoy and cool his nerves in the 6 months that the court has directed. It also is a constitutional duty upon the Cabinet Secretary to obey court orders. It is not a discretion. It is a mandatory provision. Once you hold a public office, like the one you hold, you are subjected to the thorough diaphragm of the Constitution, and part of that thorough diaphragm includes obedience of court orders. If he does not obey, in the unfortunate event that he does not obey, we also have mechanisms, both internally and externally, to address his adamancy in not obeying the court orders. So in both levels, if the IG does not respond, there are many ways that the court has given, and we also have mechanisms to deal with it. But on the second hand, if the CS is adamant and recalcitrant that he will not pursue the arrest of the IG, then we will invoke our own internal mechanisms as well as external mechanisms to enforce them. And the court has addressed that issue. Since the best way to arrest a citizen is through the National Police Service. But the National Police Service is one that traditionally embraces what we call command responsibility. I am very sure that no police officer, especially he is the most senior police officer, I do not think any junior police officer, including his deputies, will be willing to enforce this because of the strategic quagmire that will ensue thereafter. But we will still pursue other mechanisms of having him arrested, or having him bear responsibility for the office that he holds. That office is very crucial. That office is the subject of constitutional ethics. He must adhere by all chapters that touch on public officers and state officers. So if in the alternative all these don't work, there are still other mechanisms to pursue. You know, Waswahili wanasema siku ya nyani kufa miti yote uteleza. Yeah. So we are at the moment where miti now uteleza.